Studying quite a few. A lot of everything's from that written. I know. Okay.
Great channel.
Hello. Can you hear me? Yeah. Hey,
We can hear you, Bob.
okay, good. Good. Okay. I know we always have additional people come in because we're all working off of real time. That's good. It's okay. If you haven't been in many of my classes or any of my classes, or may not remember the principle of which I operate all my classes. Regardless of whether I'm talking about paragraph 6 of the contract or one of the addendums or the agent relationships or intermediary, I always talk about it from a concept perspective, not a memorization perspective. I don't need for you to memorize the contract. I need for you to know they're there, understand the concept of what's there. Going through the process, because it will always change because you're dealing with people and people are different. I look back to 1966 when I got into the business while I was in college in Abilene, Texas. I think back about people I dealt with then, buyers, sellers, agents, different people, different world, different perspectives. The world has changed so dramatically. I was talking to my son about this situation and using the example that he's walking down a sidewalk and here it is in 1970 or 80 or whatever, and you trip on a crack in the sidewalk. You kind of maybe fall and you're a little embarrassed, you brush yourself off, nobody's really sorry. The day when it happens, you look around and say, whose sidewalk is this? Who do I sue about this? Because it's clearly not my fault. It's whoever it is, that's their sidewalk. You call it. It's a different attitude, it's a different mindset. There's more stress out there than there's ever been in all my years in the business. And that's okay because frankly, it makes a good agent more valuable. Because not everybody can deal with people. One of my big challenges why I've had such a hard time in real estate is I really don't like people. It's a pain to deal with. You know, you're right. That's true. That's how it is. But one of my real actually challenges is I automatically like you until you've earned the dislike. And the quickest and easiest way for you to earn the dislike, lie to. If we break the trust, we're in trouble. But otherwise, I like you. You know, you just, especially I like you if you're a realtor. I figure, you know, that's what the world needs, is more good realtors. How that works. So we're going to talk about expectations today. We're going to talk about concepts. And you also have in your packet there, the 1-4 family contract, and you've got several addenda. And everything we're going to talk about from a concept standpoint is understanding expectations that we have. And a lot of this whole concept, this idea, expectations, came from Marcia. We're saying, you know, we really need to talk about it. And does everybody know Marcia? She's back here, sure, Marcia. She's our lead transaction coordinator. If you're not using transaction coordinator, use her. You should be. I don't care if you're new or experienced or whatever. You need to focus on your clients and on business to handle risk. Because one of the first things we have to recognize as we come into a relationship, as we come into a transaction, everyone has expectations. Many times they don't realize what those expectations are. But when you first start working with a buyer or a seller, they have expectations. And we're going to look at what some of those expectations are, you know, from the seller's perspective, what do they expect from the listing agent, what do they expect from the buyer, what do they expect from, we look at all of those so we can have a sense of it, because it's important as an agent, as you're representing a client, that you understand what we have to deal with. Just like, and it's a separate class that we deal with listing agreements and listing presentations and how to help them put up marketing programs, so forth. But here you need to have a clear understanding of the expectations of a seller. In fact, it's one of the first things that we look at is what does the seller think about the listing agent? What do they expect from the listing agent to work through that process? Now, as we go through this, and this is true for not only the folks in the class, but also our Zoomers, and don't rely on me looking at the chat or seeing your hand up or whatever, because I don't really have all that right here. Just unmute yourself. Bob, let me ask a question. Let me clarify, and we'll move forward and do it. So what I want from you is you think about the transactions you're in the middle of that you're doing, or you're about beginning if you're brand new or whatever. What's your opinion about, for example, as a listing agent? What do you think people expect of a listing agent? And on this first thing on this first page, where we look at the listing agent, what we're going to look at is what are the expectations that people have of the listing agent? What do they expect that listing agent to do, to know it, to be able to work through the process? Hello, Ms. Cynthia. Hello. So grab some material in the back. So we're looking, what we're looking at here are the different participants and their role in the transaction. So the first thing is, what do you think the seller's expectations are towards the listing agent? And we're going to presume that the seller has in fact agreed that you're going to represent them. They're going to sign off on a listing agreement with you and work through that process. What do you think that seller expects of you, the listing agent? What's their expectation?
Honesty.
Honesty.
Clients will cooperate.
Do what?
They will cooperate with you.
Cooperation. So you think that the seller would want the listing agent to cooperate with the seller? Okay. What does that mean?
To listen to them and to try to, if what they want is doable.
Good communication through the process. So if you've got a listing agreement now, you've done what we talk about in other classes. You've gone through the process. You've discussed with them. You showed them CBA, CMA. You've done the market and so forth, and they've agreed on a list price. You've also agreed on a marketing plan. You've also agreed, for example, on how you're going to communicate. Some people say, I just want to communicate by email, by text. You know, I want to communicate every time when you buy my lunch, you know, whatever it is they come up with. And you have that worked out. Some people don't like to do emails. We like emails. It's great documentation. So you would have worked all that out. And so your seller, who's now your client, you've worked out some communication, because that's a really important expectation of theirs. is that communication. They need to be relying on you. They need to understand that here's what you're going to do. But what's the big thing that the seller expects the listing agent to do for them? Get their house over.
Sell their house.
Do what? On Zoom?
Sell their house. This is Darby Merriman.
Yeah, sell their house.
Yeah.
Sell their house in the time and the terms they want to sell it at. And while those objectives may change during the transaction, as the market communicates to the seller, have something in the back there, your materials. As the market communicates, the seller says, you know what? The listing agent was being a nice person, and the listing agent went ahead and agreed to list this ridiculous price you came up with, but now the market's telling you you're wrong, and let's make adjustments, let's work through it. But the seller has that expectation, because ultimately the reason the seller is going through all this hassle, and it is a hassle. Your house on the market, have people traipsing through your house, doing all this kind of stuff, and interfering with all the rest of your life. You expect, hey, I want to get the house sold, I want to get it sold as quickly as possible, for as much as possible. And I want you, the listing agent, to be the one that guides me to make sure if I accept an offer, it's the best offer, not just from a dollar standpoint, but the best offer that's likely to close, has the highest certainty of close. And would you agree the seller has that expectation of the listing agent?
Yes.
Now, if that's true, what do you, the listing agent, have to be able to do to meet those expectations?
Be knowledgeable.
Be knowledgeable, understand what that means. What's going to have to take place for the objectives of the seller to actually happen? You have to be knowledgeable of the market, knowledgeable of the contract, knowledgeable of the transaction process. Hello, Jeannie. How are you doing, young lady? Now, one of the real benefits of the experienced agents that are here who come in late is I get to recognize you. Don't understand? And that's okay. That's good. Because that means that they must be a celebrity. They must be really important. So knowledgeable and knowledgeable not just about transaction, market, the whole process. What you can never do, and we're kind of talking about some of the rest of this in the topic, you can never presume that your seller understands the process. How does this property get sold? I kind of have a general stuff. It's especially a challenge if they've never done it, or it's been a very long time since they've done it because things have changed, or they've done it in a different state, because the closing process is different in different states. Some states, the closing happens at the broker's office, and the broker has a trust account. The broker is the one who is escrow. So it depends on where they've experienced this before, as opposed to what's going to happen here. And you need to recognize it. You need to make sure you help them understand the process. So those are all things that the seller expects of you, which means you've got to know that. You've got to know here's what they expect. And if anything that they expect is unreasonable, you want to address it now. As Cynthia knows, in the property management world and the leasing world, 99% of all your problems are handled right up front. Your problem tenants are eliminated right up front. Same thing with the seller. If they have unreasonable expectations, we need to address it right now. And I know it's incredibly hard, and I do understand because I've been there. I mean, I was a producing agent, and I can remember months that I didn't know where my rent was coming up that month. So, man, I got to get something sold right away, because I understand that. And given that, it's really hard to walk away from a listing. Not as critical right now today as it was 3 months ago. But because 3 months ago, listings were going a little different now. But still, as you go through the process, you've got to recognize when their expectations are going to make you work harder and longer, and it's not going to end up with a result. You're not going to get paid. It's not going to close. So you need to handle that right up front. So understanding the expectation of the seller. Now, what about, and we're all talking about the listing agent here, what are the expectations of the buyer and the buyer's agent of the listing agent? So what do they expect of the listing agent? Take it first one at a time. What's the buyer's agent expect of the listing agent? Communication. Responsiveness is number one. The number one complaint that we get, number one complaint that NAR has, is agents don't communicate with each other. Agents don't respond. In fact, at TREC and one of the committees that I'm on, we just revised a rule and we're sending it to the Texas Real Estate Commission in their August meeting, dealing with the response time. So that we now have a response time. And while it's still not tight enough, we can't make any tighter to do. And it's a 2-day response time, 2 calendar days for everyone in the transaction. That if you need a response back from them, we've got 2 days. Otherwise, you're in violation of correct rule. Cynthia?
I recently had a listing come up and of course I got blasted by email of all offers from investors and immediately forwarded it to my seller, and my seller was insulted and said, don't respond. And she decided, this is the buyer's rep, she decided that she was just going to bombard me every day. And when I replied to her and said, you haven't looked at the property and you're giving me a lowball offer. It's hard to take you seriously. Go see the property and then submit an offer. And she just went nuts on me and said she was going to forward the thread to NAR and I'm obligated to turn in every offer, no matter how many times she said.
You are, but you bring up a really important point, an expectation, something you address with the seller right up front. If you've got a piece of property that you expect a lot of investor activity, you get your seller in writing, such as an email, to give you instruction. If you get, especially if you get emails, if you get phone calls, get inquiries, and they're not within the parameters that we've already decided on, you have my authority to not send them to me. And you have my authority to tell the buyer's agent, my seller has said no response on these. When you have, because that's what you need to be able to do. Now, you can't keep idiots on the other side from continuing to bombard you. That's just the nature of the beast. And you've got to you have to deal with it, but you can ignore them. And you don't have to answer the phone calls. That's why we have caller ID.
Right. So the key is that the seller has to instruct.
Seller has to instruct. Unless the seller instructs you, you've got to present all offers to the seller, and that includes verbal offers. And you want the seller to say, I only want offers within these parameters, on a track form, signed by a buyer. If I don't have that, if it's just an email, if it's just, a phone call, I don't ever want to see it. You not only have my authority, you are prohibited from calling me and telling me about those. I don't, it's bad service if you do that and the seller says don't. So you need to cut that off right at the beginning. Now, that instruction from the seller may change over time depending on what's going on with the property. It may be that, you're going to have to adjust the price. It may be that the market is such that at some point in time, seller says, we're going to need to sell this, and although the market's telling us we're too high, send me everything. I want to see anything or have anything here. Seller gets to make that decision. That's going to happen over time because of what's happening in the market. Question?
Yes. Do we have a specific document that we can actually present to the seller for them to sign?
No, good question. We don't have. What we do is we ask them to just email.
Okay.
Yeah. And tell us, here's what. And the key is, and probably not a bad idea, is to create something to explain, here's what we want to have, here's what we want to have, and whatever it is the seller is going to send us. You want the seller to say that, because not only do you need the seller to say, I don't want to see these, the seller also has to authorize you to tell the buyer's agent, hey, here's what my seller has instructed me to do. So they'll never see this. Fortunately, in Texas, the seller is not required to even acknowledge the existence of an offer. Some states it's not true, but it's true in Texas. So the seller giving you instructions, I'll say, I don't even want to see it. That's okay. Ollie?
Like in Janet's case, could she have replied, I forwarded your offer to my seller? Period. I mean, you don't have to have it give any more.
Yeah, if you don't have that instruction seller, if you don't have that instruction seller and you send all the offers over, then, just between realtors, you sense that I have submitted it. Now, there was a new thing that came out last year in the Code of Ethics, in our Code of Ethics, Article 1, that a buyer's agent, for example, can request in writing of a listing agent, I need for you to confirm that you presented the offer to the seller. And by the way, the listing agent can ask the buyer's agent to confirm that you presented our counter offer to the buyer. So that's a new requirement in Article 1 of the Code of Ethics. So, you can say to the listing, I need proof that you've done it. Now, There's no way to protect this big lie. Oh, yeah, I've got it, you know. Because that's one of our big concerns is we don't get any response. We don't think it was ever presented. Just have to deal with that. So buyer's agent, as you go through that process, you're going to deal with things Cynthia brought up. You know, you're going to deal with people who, because that's their practice. That's what they do. They have a lot of investors and you're just throwing a lot of stuff up against the wall, seeing if something will happen. And they know eventually enough numbers and something will happen. And what you got to do is protect yourself, protect your seller, and deal with that process. Anticipate as you work through it. You may not automatically know because the market is shifting so much right now, whether or not this truly is a property that you're going to have that. But as soon as it begins to happen, you may want to immediately contact yourself and say, okay, here's what's happening. Here's an option. Here's something we can do about this. And then get them to send you an email saying, yeah, here's the deal. So that's the deal with the buyer's agent. Remember, what we're talking about is how these people have expectations of a listing agent. What is a buyer's expectation of a listing agent? What do you think a buyer thinks about a listing agent?
Responsiveness, but communication as well.
Now, we expect the buyer to have communication directly with the listing agent. No, not normally. It can happen, but the listing agent is only going to communicate with the buyer directly with permission of the buyer's agent. And if the buyer's agent, if the buyer contacts you as the listing agent, say, you know what, you've got an agent, that's how the communication needs to happen, unless I have permission from your agent. Because it's very risky if you talk directly to the person.
I'm sorry, my phone.
So the buyer, in looking at the listing agent, is expecting the listing agent and their agent to have all those conversations. And what the buyer is really looking at the listing agent to do is to honestly present their offer and their case to the seller. They're really trusting that because, you know, the people are concerned that, well, how come they didn't respond to my offer? How come they didn't do anything? What's going on here? Work through that process. But the big expectation of the listing agent is going to come from the buyer's agent. If you're a buyer's agent and do we go ahead and call out her name too? So, and just because she came in late, yeah, Jana and Jenny and Jenny.
Jay.
I don't want this to be any encouragement to come in late and get ready.
I was coaching someone.
Here's the other part about showing up late as a realtor. You always have an excuse. Good story. I was having
On the phone with a client.
Yeah, I was on a Zoom call this morning for our education department, CCAR, and didn't know it, didn't find out. Jessica Barker, who is our director of professional development at CCAR, her parents live in Abilene, Kansas. And last week, their house caught on fire and burned down.
Oh.
So she's up there now trying to take care of it. She said, and the problem is, it's a little bitty town. And there are like only 7 houses on the market. And there's virtually no rentals. So they're having to work and figure out. So her focus now in dealing with that. So sometimes you'll have a situation where someone is just not responding, but things going on. I mean, middle real estate, life happens. You kind of have to work through and deal with that. But if you're the buyer's agent and you have the opportunity to talk to a listing agent, have a conversation with them, I would encourage you to take a picture. So you remember what that looks like next time. Because sometimes it's a real hard thing to get now, let's look at the title company. What we're talking about here, and if I go to the next one and you say, wait, let's still deal with this. What do you think the title company's expectation of the listing agent might be?
Information.
We do have a seat up here,
Okay.
a seat over here.
Thank you.
Whatever you get. So you think what? Information. So the title company wanting, what kind of information would the title company want from the listing agent?
They have it.
Yeah, all that information. And the title company will send out an information sheet. Probably about 60 to 65% of the communication and transaction from the title company is through the agents. Not all of it, but most of it. And so you'll want to, as you go through that process, the title company says, yeah, we see later, title company's expectation of seller, which is a different conversation. But when they look at the listing agent, they expect that communication, they expect the information. Typically the contract is delivered to the title company by the buyer's agent. And that's because they're going to send that and probably going to also deal with first party option fee, things of that nature. Not always the case, because you may have a buyer without an agent, in which case it's probably the listing agent going to be addressing. So the listing agent has certain expectations of the participants in the transaction, and that's what they look to from the time he was looking to the listing agent, make sure that we move forward on the transaction and what's happening. Because sometimes they have to look to the listing agent to encourage the seller, for example, come with a payoff amount for existing loan and to do the things they need to do, especially if you've got things like probate and a trust and things of that nature. Listing agent may have to get involved and try to help make sure that stuff gets to the title company. What do you think the appraiser is looking to the listing agent for?
They used.
Well, a good appraiser wants the comps. You may want to have information at the house for the appraiser. They also want you to work with them on access to the property.
It's funny, because they have to get in.
Yeah, they would get in. Because is it valuable for the listing agent to have the property appraised?
Yes.
Yeah, most of the time.
You want.
Maybe not all of it. Depends on the transaction. But yeah, so any good information that you have, and if you've got a really tight situation where you don't have a lot of comparables, you may begin to look at things like pendings, active options, things of that nature, and provide to a seller. If you're in an area where there's a lot of new homes, try to work with the new home sales reps and see if they have the information, because they'll have information on sales that don't show up in MLS, which is primarily what the appraiser is looking at as you work through that. So there's certain expectations. So this first part here gives you a sense of, you're the listing agent, here's what these other participants in the transaction are expecting of you. Now, the important part of that is because you know that's what they're expecting of you, you need to know what it takes to provide that. You know the value of it. Understanding this is an important value proposition conversation with the seller. The seller needs to know you understand how this works. You understand what people are looking for, and you understand what you need to do to make sure it happens. And the better you understand that process, the better they're going to understand your value proposition and why you're charging for 15% commission.
Wow.
See, that's part of our problem. I'm such an optimist. You know, if you're charging 12%, you can negotiate down to 6 or 7. Say it. Okay, go to the next page. Let's see how big trouble the buyer's agent is. So there are expectations that people have of the buyer's agent. Now, we need to make sure, and I don't want to step over and presume something. We all understand that if you're the listing agent, what I would mean by that is that you have a valid executed listing agreement with yourself. If you're a buyer's agent, you have an executed buyer representation agreement with the buyer. Now, we understand that an agent relationship, an expressive agent relationship, can be created without anything in writing. Very bad business decision, but that's the law. You can be fully representing a buyer and have nothing signed off on. You can have no protection at all for your commission. So we want you in a buyer representation agreement, which is going to help set up all the expectations of the parties transaction. So what do you think, first shot here, what do you think the buyer is expecting from the buyer's agent?
Find the house.
Find them a house. Now, in order to find them a house, what do they need to know?
Period.
Market. What's going on out there, right? The buyer needs to have some experience. And I know most of you have heard me say this, and you get a little impatient with me. On the geographic competence issue, your buyer, the buyer expects you to know the area that you're showing them properties. Which means you didn't just pull it up in MLS. You've got a better sense of that. Now, I know there are many situations where we kind of depart from that a little bit. You're taking a risk when you do it. Part of the risk is a TREC issue. Part of the risk is also not best service to your client. We've got a number of agents who have fallen in to the habit. They're doing a lot of stuff in Fort Worth. I understand you got all good MLS information, but there's things going on in Fort Worth that really may affect your buyer's circumstances that you need to really be understanding. You really need to go through, because your buyer is going to expect you to, as you find them a house and negotiate a good deal, that you understand more than just what your CMA is if you pulled it up from MLS. You ought to go a little bit beyond that as you work through it. Becomes even a greater challenge if you're doing anything beyond just a single family home, if you're dealing with acreage, if you're dealing with geographic areas that are very challenged. So you really got to be able to do that, because your buyer is going to expect it. Now, different buyers are going to have different levels of expectation. Many times a buyer, you've got a relationship, you've worked with them a long time, good relationship going there, and they understand your limitation. In fact, you've done what Bob asked you to do. You said, you know what? I've really never been to Midlothian before. I'd be happy to take you down there and show you some houses and go off on MLS. It's not a problem. But I really don't know what's going on there. And that's okay. We know you, we like you, we visit you. I don't want to break in a new agent right now, so we're going to work with you. And so you've given them that, kind of a disclaimer there. You've done it in writing. It's an email that say, yeah, we want to work with you. So if it hits the fan and hits the TREC complaint and the trade investigator find out, well, I said, you know what? Yeah, they told me, they explained to me, there are the limitations. Here's what we're doing with it. As opposed to a buyer who's really anal about all that stuff and they're going to be demanding you already seen it right off. That may be a buyer you want to refer out. We've begun to see lately referral business is really getting to be some pretty good business, especially with the price of gas. So if you can refer a decent sized buyer to an agent in Fort Worth, rather than continue to drive back and forth, at the gas price we've got now, that could be a really good idea. Referrals can be a good, in fact, if you don't do that, you may be leaving money on the table once you work through it. Look to do that if it makes good sense. But make sure you do it, because first thing buyer's going to say, hey, buy me a good property. What else is the buyer going to want you to do? What's their expectation?
You can negotiate.
You can negotiate a good deal. Now, being able to negotiate a good deal requires knowledge on several different levels. One, knowledge of the market, knowledge of that specific property in that specific neighborhood, knowledge of what your client situation is, as much information as you can gain from the seller side to know what the negotiation points are. We probably will do again a negotiation class. I think I mentioned this in the last class, and we'll talk about, I kind of finally refer to it as the dirty tricks of negotiation. So that not that we learn how to do dirty tricks, but we know how when they're being played on us. But they expect you to be their advocate. One of the phrases that we have a hard time getting past in lawsuits and TREC complaints is when the client says, I just trusted my agent. I trusted my agent to know what I needed. I trusted my agent to take care of me. It's hard to get past that, because if that's what the judge hears, that's what the TREC enforcement attorney hears, say, well, if they trusted you, how come you violated the trust? What did you do? And the way you violate the trust is you didn't understand their expectations. And if they have expectations, as I mentioned earlier with listening, that are unreasonable, you need to address it right then. You say, you know what? I'd have to Google up Midlothian. I am not even sure whether I know it's somewhere south of this. You know what? And I don't know if they've got a Dairy Queen there or not. So I'm going to places that have good dairy. Yes, ma'am. Is this a question about Dairy Queens?
Dairy Queen, yes. Has there ever been a case where a buyer came back on the agent because they felt they overpaid? Because I have nightmares about this. Because I've had
lawsuit over in Fort Worth, actually mid-cities.
Okay.
She brings up the question, and so I make sure, Zimmers, that I repeat this so you guys hear it. A case in which in this particular case, now this was the opposite side of that. This was the seller who sold the house for less than they should have, but it hadn't fully gone on the market.
Okay.
And they found out that someone else who sold the house and put it on the market, made 20,000 more. We don't yet have, we know we will have, we don't yet have any actual cases that have gotten to the appellate level. So we don't know about them until they get to the appellate level. That's when they're published. So until it gets to that point, all we hear is what agents tell us. So we think because of the prices in the last year and a half, where buyers are way overpaying. That's why we have that new advisory board for buyers. If they're paying way above what's list for value and so forth, they get to make that decision, but they need to know if they've got to turn around and sell this thing in the next year or two or whatever, they're very liable to have financial consequences. But this market is new enough that we don't have any cases that have worked their way through the courts, but we fully expect it. And many of my broker friends say, yeah, we've got one of those forms too. But have you had a situation where
I've had people, offer 120 over.
Oh, yeah.
And it's
which is real expensive because the list price is only 100,000.
Yeah. I really have nightmares about this.
Well, and you're right, and it is a concern. And the reality is, if you don't have a good conversation with the buyer or use that form, which is on their intranet, the buyer later, their memory of what happened is you convinced them to pay that much more. And that was all you. Holly, do you have a question?
Yeah, well, Paul Jeske's wife's current experience for being on the
In a jury? Yeah, but that didn't have to do with the price, did it?
It didn't, but the fact that it was an agent that bought, and so there's an agent who bought her own house and facilitated her own deal, lives next door to somebody. They have a koi pond and it's lakeside, it's all wrought iron gates. She's suing her neighbor because the sound of the koi pond bubbling impedes on her quality of life.
Oh, yeah.
But because she never went in the backyard to check out the house, she personally bought.
Oh my goodness.
And if they did it's hard of hearing, the lawyers have had to repeat every question for while she was on the stand. She can hear this koi pond bubbling. It's like, does that to me? I would think if I filed a lawsuit against my next door neighbor for that I just advertised in neon letters that I am incredibly incompetent.
Yeah.
And that would open me up a lawsuit to everybody that I've ever served because I've like admitted in court that I'm incompetent and not thorough and not good at my job.
It's amazing the things that appear to be reasonable that people just don't do. For example, as a listing agent, what would you ask every buyer's agent?
Have you seen the house?
Well, one, you want to know that, but you'd also say, does your buyer have a house to sell? The buyer doesn't have to tell you. Unless they want to create that contingency, they don't have to tell you. You're always going to ask it. And in my multiple thing of it, there's 9 criteria after 7 months, but you always ask 5 things you always ask of every. So a good listing agent do that. But it's amazing the number of listing agents, not us, who never even ask for proof of funds. Say, oh, it's a great cash offer. It says we love cash offers. They have no idea where the cash comes from. They don't ask the questions. So things that make sense that we think are reasonable, people are doing something otherwise, and we go, yeah, that's just, how's that even working? So you can't expect people to make good sense out there, and you just have to prepare and work through it and make sure you protected your client working through it. So in dealing with the buyer's agent, the buyer, one, say, hey, find a house, negotiate, which means you've got to understand, you've got to have some basic negotiation skills. And unfortunately, in our industry, we've got a number of negotiation courses. We'll do one here and talk about it, but it's only going to be a 2-hour deal. And in dealing with the negotiation, it's a valuable thing. It's not the most important thing. When you look at the scale and you look at the thing, here are the things that a buyer principal expects of their agent. Negotiation is like number 7 on the list. It's not at the very top. Until things go wrong, until they don't get the deal they think it should get. Well, they never did really negotiate. But negotiation, being an advocate for them, particularly in multiple offer situations, one of the things you do as a buyer's agent is you find out what really works for the seller. So you can craft your buyer's offer in a way that's really attractive to the seller. But you've got to make sure you help your buyer understand, I'm not doing this because I was flipped over to the seller side. I'm doing this as your advocate. to help you improve your offer. Now, none of the things that I'm gaining information on from the seller should make you put something in the offer that you're not finding acceptable unless you're going to be happy. But I'm just saying, here's some information that might help your offer be accepted, but you've got to decide if it's okay or not. And one of the things we're going to talk about in miscellaneous are exclusions. Buyer may say, oh yeah, I'm absolutely okay with those being excluded, or maybe I'm not, as you work through it. So your buyer expects you to find the property that they want, be an advocate for them, help them negotiate. Holly?
They expect you to be knowledgeable, not just about the market, but about other things.
Oh, the transaction, the contract form, the offering process.
But I was gonna say just about it. I had a client who disclosed, but she came to me with her own lender to begin with.
And we're good with that.
Yeah, that's fine. But they expect you to have some basic knowledge in communication. But when I started talking to her lender, we had one conversation like 2 months ago when we started, and he led me to believe that she could have a very good credit score and that that's why they were going to be going FHA, blah, blah, blah. We got further into it. I had a conversation with her one day and she brought up her credit score, which was quite nice. And so I got back with her lender. I'm like, why are we doing FHA? The young lady had plenty to put down. She's really got her act together. And I'm like, why are we going FHA instead of conventional, given the amount of money she's got to put down in her credit score and stuff? And he's like, well, blah, blah, blah. I'm like, well, can we run the numbers for both? Because there's different expenses to doing an FHA kind of thing. And
so you need to be,
gently help.
To Holly's point, you need to be knowledgeable enough about the different pieces of the puzzle, financing, the title, the appraisal process, all that. Big thing with the financing, we don't want to become a loan officer. We don't want to be at that level, but we want to know enough to know whether or not we're talking to an intelligent loan officer. If you understand, just like in her case, if you understand, here's how this works, here's why someone might be in a conventional versus FHA, here's why someone legitimately should be on an FHA or a VA, here's what's going on there, and you understand the process well enough, you're generally going to have a good sense of qualifying ratios, what changes those, how that works, without being able to go through the process. But you ought to be able to do a quick thumbnail qualifier. You've got a buyer and say, well, here's what I've got here for you for now, for kind of thing. We're in that process now where we're beginning to see lenders and we're seeing builders do buy downs. And you need to understand the distinction between temporary buy downs, permanent buy downs, discount points, change interest rate forever, things of that nature, adjust rate mortgages, to see which of those types of things should your buyer consider. As they're dealing with a lender that you didn't recommend or that you don't even know, so you understand what's going on there. Because one of the worst things that can happen is you're sitting there and you call the buyer, your buyer's lender up, just see what stats it, and the buyer's going to say, oh, everything is great, everything is great, everything's right on schedule. You go, oh my gosh, I had no idea it was that bad. They just told you what you thought you needed to hear, and everything's terrible. You know, well, you know, anyway, you might say, oh, yeah, I forgot that. We need to look at that contract. Let's put that on our schedule. Let's look at that contract a few weeks ago. Some lenders, you know, they usually don't file. And one of our fears is if it's a bad lender, when you start bugging them, they move it to the bottom of the pile. And it really creates a challenge to work through it. So you need to know enough about how all the pieces of this stuff pull together as you deal with it. So your buyer expects all those things from you. One of the things that's illegal in Texas is for an agent to both be a real estate agent and to be a loan officer at the same time. We prohibit it. It's an absolute prohibition in our offices. You can't do both. It's legal because certainly in my opinion, being a loan officer is complex enough. Certainly being a real estate agent is complex enough. I think you'd have to be close to being a genius to be able to do both of them adequately. And you're not going to do it in our office. So just think it's not. Now, let's look at, because remember, we're looking at here, this question, Marcia?
Not a question, but something to add.
Okay.
That the buyer expects the buyer's agent to explain the paperwork, what they're signing, whether it's our office paperwork.
Yes, every single form they're signing. Yeah, and you know, and one of our challenges, often you're doing this electronically. You're doing it one piece at a time. And when you're making changes, you send that page over, terrible. Because they don't understand how that impacts on the entire transaction, on the entire contract. So she's right. You need to make sure that when they sign off on something, that they really understand what they've just agreed to. Because remember that little phrase you're gonna use later? Yeah, I didn't really know, but I trusted my agent. It's a bad thing. One of the little pluses that we are getting, mentioned this in other classes, there's a fairly significant trend. In fact, we've got a case in one of these e-courses where the courts are looking to the people who signed the contract and holding them responsible for understanding it. You signed it, you agreed to it. Did you read it? No. Yeah. What do you mean you didn't read it? You signed it. You're committed to it. You agreed to it. You represented to the other side of the transaction that you understood what you disagreed to. And you've got to be able to do that. So that's important. So good comment. What about, again, we're looking at the buyer's agent. What does the buyer's lender and appraiser expect from the buyer's agent?
Communication,
Communication about what?
when they are in the process of house hunting.
Because the buyer's lender is going to, at some point in time, need a copy of the contract. Going to need a specific property to work through that. You know, they've done a pre-qualification or pre-approval, and you know, okay, here's an actual house link, put you in a file and start the process and work through. So, you know, the buyer's lender is going to expect certain things from the buyer's agent working through that process. Right up front, when you take on a buyer client, you need to talk to whoever the lender is going to be and see how that communication goes. Because if it's not going really well right now, it's not going to get better. And you've got to decide as agreements how much it's going to impact on your ability to represent them as you go through the process. What about the appraiser? What's the appraiser expect of the buyer's agent?
Access to the property.
Do what?
Access to the property.
Yeah, but we're primarily looking at the listing agent for access. But the buyer's agent, as you go through the process, a good buyer's agent, especially if they have any concerns at all on it appraising out, is going to provide the appraiser whatever he needs, such as comps. Can't just rely on the listing agent who've done all that. The buyer's agent may have to give the information to the appraiser about here's information on showing services. Here's how you have access to the property. Here's information on the property. It's vacant. It's not vacant. And here are our restrictions on showing. So the buyer's agent, from that standpoint on access, we have to make sure that you go through all that. We want to make it as simple and easy for the appraiser as possible. Now, that's not a huge problem for a good appraiser, but the middle of the road or the bad appraisers, you got to do everything you can to make your life a little better, to encourage them to help you out here. Yes, ma'am.
Sometimes why the buyer selected that property over a lot of their other choices. What prompted them to make the offer that they did?
That's an interesting point. Expand on that.
Well, I mean, it's not happening as much, but in multiple offer situations, when your buyer goes, like Jeannie said, 100,000 over list price, why that was important to them to get that particular property. An appraiser doesn't have that knowledge necessarily. So, I mean, if it's the only 5-bedroom with a 3-car garage and Plano with a pool,
yeah,
and the appraiser doesn't have that knowledge, that might be important.
They need that additional information, and that could come from the buyer's agent. Sure, it's a good point. Okay, yes, ma'am.
A list of all that phrase that is heard in the house.
Yeah, everything that's in that property. Maybe this maybe a little bit to your buyer says, yeah, we love this property because of the upgrades, the this, the that, whatever. That could help the appraiser as you go. These may be things that are valuable to the property that you can't just walk through and see. Upgrades that have happened to the systems, electrical, other things in the property. So yeah, that's good information that an appraiser ought to have. And that could come from a buyer's agent and from a listing agent. But a good buyer's agent can't just rely on a listing agent to take care of those things. Buyer's agent needs to make sure they're done. Yes, ma'am.
I would say that also that between the lender and the appraiser, they're expecting us to help educate our buyers. A lot of times people don't realize that there's going to be generally an expense to an appraisal that they'll have to pay up front before the appraisal goes out, depending on the lender you're using. Some send amount without paying, they take the money at closing, but still there's a cost to that. So educating your buyer on the costs that are coming up.
The cost and the timing issue. Depending on where the property is, you can find yourself at a timing issue on the appraisal. Because appraisers in a lot of ways are busy, although they're a little less busy than they were a couple months ago. But if you've got a property the south of the country, we got one right now that we're going through a battle. It's actually the Rockwall office. And we deal with the cost of surveys, for example, and the appraiser, and it's property out of the country. And so you deal with some different challenges. And the cost is fairly significant. Angie's looking through, so hopefully none of you are in trouble with our MCA. She's looking it through, you see, okay, who's in there that I need to talk to? Now, again, we're talking about the buyer's agent. What does the listing agent expect of the buyer's agent? It's the number one thing.
Bring the willing and able buyer.
Well, we do want that. We want communication. We want communication. My number one complaint that I get from agents is when the agents aren't talking, and the agents aren't communicating. That's the thing that creates more problems than anything else. What the buyer's agent wants from the listing agent is communication. And we understand, Larry, you're good at this. Situation with the buyer's agent, you make the listing agent a good friend. You establish a relationship. And I think you go a little too far when you're taking those 3 quarts. We're taking the 3 quarts too far. But he does. He established that. He understands the value of that relationship and how big a thing it is as you work through it. Because the listing agent needs to feel good about this buyer's agent. You go through the process. The listing agent is going to have certain expectations of the buyer's agent, and a lot of that's going to come from how well the buyer's agent does in establishing that relationship. And that could be a huge thing. On my little criteria list, multiple offers, one of them is who's the agent. And that's a real difference as you work through that. So you have to work through that. What about the title company? Which title company looking to the buyer's agent for? Pardon me? Contract, or money, obviously, all of that information. All the things the title company needs moving forward. They go through it. Marcia, do you see things that title company that you have to have the transaction process make sure that the title companies get?
The title companies want to know your client's contact information up front so they can communicate with them. I need to explain some things to them like HOA, title commitment.
Yeah, okay.
Just keep doing your thing.
Okay. So next page, we're looking at the buyer. What we're looking at are different participants in the transaction and what are their expectations of the buyer. For example, what does the buyer's agent expect of the buyer? What's one of the things, an important thing in the buyer rep agreement at the very beginning? The exclusivity of the relationship. Yes, the buyer's agent expects the buyer exclusive relationship, expects the buyer whenever they go into an open house or talk to a builder, say, oh, by the way, I have an agent, here's her card, here's his card, here's the information. So they expect the buyer, the buyer's agent expects the buyer to understand that relationship and understand the commitment that we expect from the buyer. We go through these cycles of buyers who go around us. And like, well, I didn't know. Which means we didn't have that conversation of expectations early on with that buyer. Make sure they understand here's what we expect of you as you go through it. Make sure they understand when we put something in paragraph 3 of the buyer rep agreement, dealing with the market area, but they understand what that means. And by the way, you need to understand what that means. If you've got Collin County in the market area and they buy property in Dallas County, your buyer rep doesn't count. So you need to understand what that means, how that works. Some investors, by the way, that you may choose to work with will work with you on specific properties that you've introduced them to. And you put in the market area, any property, you may have a list of, but any property that you provided them information on, or introduce them to, then that buyer rep agreement only applies to those properties, which means that investor can work with multiple buyer's agents at the same time in the same market area. So you need to understand if you choose to work with an investor that that's what they need to do. And you feel like it's a good situation, you can do that because of how you define the market area in the buyer rep agreement. You should work through that. So a buyer's agent expects the buyer to understand the market, the buyer rep agreement, what they've done and kind of how that works, you should deal with that. Anything else about the buyer's agent expectations of the buyer? Yes, ma'am.
Can you go over when and your great script for releasing, firing a buyer when it's the appropriate thing to do? You have a script that's really good.
Yeah, I do have a script. I'd be happy to send you one. And it's a great little script because it's true and it's made to benefit the buyer. And you can use the same script for a seller. But what you say, you've got a buyer who, for whatever reason, it's just not worth it anymore. You're not going to deal with them. Maybe they're a real jerk or whatever, or maybe that reason, maybe they lied to you, whatever the reason may be. And you say, and your script says, it's clear to me the level of service you require is beyond that which I can provide. It would be unprofessional for me to stay in the relationship just for a potential commission. Therefore, I release you from our agreement. And you do that in email, you can do that in writing. And you can do that as a precursor to having them sign off on the termination of the buyer rep agreement or termination of list agreement. Now, it's a true statement because they are asking more of you than you're willing to do. And it says it benefits them. Because you're saying, you know what, I shouldn't stay in this just for a commission. In fact, one of the things that we've learned, we got a couple ladies in this room who've learned it, is that when we're willing to walk away from a commission, it changes how they see the situation. Now, you've got to be prepared when you say that to a client. Easily half the time, no, please don't. We love you. You need to make the decision right up front whether you're going to still fire them or not, or you may say, okay, I'll put you on probation. You screw up one more time and you got it. So you decide how you're going to move forward and how you're going to do your work. But yeah, and that's something. One of the things we encourage you to try to maintain relationships, try to work through it, for some people, it just can't be done. And my philosophy is fire them sooner rather than later, because it's not ever going to work. Now, I understand it's really hard to do the day before closing and a commission check coming in. You got the next Mercedes payment coming out, but the reality is we will support you if you want to fire them. It's going to be a judgment call on your part. And depending on the circumstances, we may or may not send a demand to them for the commission. It depends on what's really going on in the transaction. We've had a number of situations where we've been successful in sending a demand notice to them for the commission. In some cases, we've been able to settle. Most of the time, frankly, it doesn't work. And it's incredibly rare, especially on the buyer side. We're just not going to go to court. The courts just don't support buyer reputation at all. I mean, some of them are just offended by it. So it's really a hard thing to enforce. Some states almost impossible. It's a little better in Texas, but still. That's because we were the number 3 state in the country dealing with buyer reputation way back in the 80s. Yes, ma'am.
2 things. Number 1, we can't use the word script anymore in our.
What's our new word, Jan? Yeah.
It's either dialogue or conversations or verbiage, anything else. Okay. And number 2, Wanda Pilen has her hand up, so she.
Oh, hello, Wanda Pilen. What do you got? Unmute yourself and talk to them.
Well, I didn't know I had my hand up, but I'm enjoying everything so far. And I did.
Do you have any questions? Do you have any questions or comments?
Not yet. I'm just here to learn from you, but I didn't know about not using the word script. So thank you, Jana.
Yeah, I didn't either. It's good to know.
Yeah, why not?
I don't know why. Okay, so explain to him, Jana. Why not?
Multiple brokerages, companies, Keller Williams, Century 21, Compass, it didn't matter. Several of them are under a lawsuit now, in which sellers are suing these companies because we script the sellers on how much commission they have to pay. 6%, right? We say that a lot. So therefore, there is a massive lawsuit going right now. And therefore, you will notice our scripts and role play class is now called dialogue and role play. You can call it real estate conversations. You can call it anything else. Just don't call it a script any longer.
It's important how we say what we say, and who we say it to.
Words matter.
Yeah, words do matter. So Anybody else I've missed on the Zoom? Thank you for reporting that. Okay, we're good. Okay, so, yes, sir, question, please.
So that word scripts, they're trying to tie the word scripts to the term that has trust, the price setting.
That's his point, could be. That we're in collusion. Yeah, that they think we're in collusion at some point.
Oh, then we're.
If he wants to say, they're gonna say that.
Yeah.
Not saying we're.
Well, here's what you gotta,
There's a case.
I'm not presuming this is the Department of Justice case. Is that right?
I would have to ask the KW Maps. They're the one that told us.
A lot of things that we have to understand, it's unfortunate, because they're doing with our tax dollars. Department of Justice is very clear, we're guilty. They just haven't caught us at it often. We're guilty. It almost doesn't matter what. I mean, one, they're clear we charge too much. And we're not worth what we charge. That means none of them have ever been in real estate, not successfully in real estate. Maybe they're in real estate and it was terrible and they couldn't make it work. So I said, well, that's bad. And so now you don't have everybody in real estate. So, but you know, that's one of the reasons we got NAR. The reason we got Texas Realtors is they've got lawyers, they've got attorneys to help us work through all this. And they've got lobbyists to help us do with it. Because, you know, as an industry, we are a target. We're not the only industry that's a target. The medical profession is also a target. Of late, in spite of the fact that they have very strong lobby, attorneys have become a target. We've got a really good group in Texas, TLR, Texans for Lawsuit Reform, that's done a really good job of trying to weed out the really predatory attorneys out there. And we find ourselves having to deal with them from time to time. But it is a challenge. So I'm glad to hear about what we change. We want to cooperate. It's not a hard thing to do. It's just, let's just change what we say or how we say it. It's not a big deal. It'd be interesting to see if that shift or that change has a final changes how the result of the lawsuits or whatever. So it'll be interesting to see how that works as you work through it. Now, let's look at the seller. And let's look at these these 4 cases, what the expectation of these people are to the seller. And I joke about this a lot, but I'm just deadly serious. Unfortunately, I've seen too much of it. What's the number one thing as a listing agent I want to know what I expect of the seller? He can sell the house. He owns the friggin' house. And he can sell it. He can come to closing and sign the docs and transfer title, because not all sellers can do that. We've got one going on right now, and I don't know the late of what we're doing with it, but the seller doesn't really own the house. His ownership is under a contract for deed. He has an equitable interest. He can only sell it under the terms of that contract for deed. He has to disclose to any buyer, my ability to transfer title to you is based on my ability to acquire title from the actual owner of the property. We would have the challenge happening to people who are in a probate situation, a trustee situation, some action of the court in which they may not have the full authority. Anytime you have a situation in which yeah, there we go, does he? Yes. I think that is go around and try to. Yeah. So anytime we have a situation in which there's a third party involved in approving a sale, the buyers need to know that. Buyers need to know that it's important to have to approve the sale. There's a trustee in a bankruptcy situation, all kinds of different reasons. If there's a divorce, if they've already filed for divorce, we now have a court involved in approving a sale. So we need to know all that. So as a listener, I need to know what your ability is to sell this property. What else is involved? Who else is involved? And especially when you've got a situation where you quote unquote inherited the property. Oh yeah, I got the property. Yeah, I inherited the property. Well, really? Has it been through probate to in fact perfect the will? Or has it not been through the heirship affidavit? What have we done here to go through the process? You don't want to find yourself misrepresenting to potential buyers that here's a piece of property. If you want to buy it, we've got the seller and the seller can sell it to you. Well, it may not be the case. Maybe somebody else involved to help prove the seller being able to sell it to you. So the listing agent, first of all, needs to know this seller really owns the property. You can't put a property in MLS. You can't do a listing agreement unless you have fee simple ownership. Doesn't mean whether they owe money or not, but they have that fee simple ownership, not equitable interest, but fee simple ownership. If they don't have that, that's a statement that's actually required in our Texas Rural Listing Agreement, and MLS requires. You can't put a property in MLS that the seller has just equitable interest. So we need to know that's the case before we, as a listing agent, before we move forward and spend time, energy, and money trying to get that thing sold as you work through it. So that's what's one of the first big things. Yes, ma'am.
Find it.
Find what?
The fee simple ownership.
Well, it'd be in the deed. When you pull up the record, you pull up the deed, which is public recording, it establishes that fee simple ownership. It establishes whatever level that ownership is. And if you're not sure, you can have the title company you do business with do a quick search, and they'll determine that. It's not probably for most sellers. And I have to say, okay, now you do have fee simple ownership. No, we owe money on it. That's not what I'm asking. If it's free, you'll hear it. We're gonna ownership. Oh yeah, we got a deed. Well, it's not a total deed, but it's kind of a deed. Yes, sir.
So we had a seller. The house was owned in a trust. And I met with the sibling who said he was the executor and he provided us a copy of the trust agreement.
He's a trustee. Executors are in wills. Trustees are in trust.
Okay, he was both.
Okay.
What's our responsibility to verify the accuracy of that statement?
We explained to him the title company is going to need a copy of the document. Did you find him?
Yes, we did. Kim Davis.
That's the front door. Did we finally get him to the front and get him to see someone? So back to your what title company, you laid off on the title company. The title company is going to need documentation that shows whatever authority this person thinks they have. It's more than what they say. Yeah, I'm the trustee, I'm the executor, or I'm the heir. I got the house in the divorce, whatever. We need documentation.
So we should delay actually listing it until he verifies it?
You should delay listing it until you know for a fact they have the authority to sell it. Because remember what happens when you list it. You put it on the market. You're telling a buyer, we represent a seller who can sell you the property. Did you just lie to them? You say, well, it looks pretty good to me. It's kind of looks.
I'd say I stretched the truth.
Yeah.
I didn't lie.
It is a lie. It's actually a lie. It's not a stretch. It is a lie. And that's one of the things as a buyer's agent that I rely on you, the listing agent, to have. And this is one of the things you got right here. Is I rely on you, the listing agent, to go through the process and determine that you've got to sell the property. If I'm going to spend time and money, option fee, inspections, appraisers, all like that, I need to know if I, the buyer, do everything I'm supposed to do, I can own the house. You better not be lying to me about whether or not that can happen or not, or the lawsuit's going to be you. And unfortunately, when it's you, it's also Mike Brody. And you don't want Mike Brody to be on the other side of the lawsuit. That was something you did or didn't do. Yes,
remember recently I had one where the spouse was deceased and
that is ran him off. He said, that's it, I'm out here.
It had been an argument from the heirs and it went through arbitration.
Yeah.
Because they
couldn't agree. The heirs couldn't agree on who has the authority.
The court arbitrator awarded the right to sell the property to my client.
Yeah.
Right? And you reviewed that. I brought that. That's what you should do. Bring it to Bob. He read it and said, yes, it clearly says right here.
Yeah, because when you, and we're doing this without practicing law.
No,
when you have something from the court, we rely on the court documents. Now, we also tell our clients that you need to seek legal advice to make sure this court document does what you think it's doing.
Which
you did.
which you told her to do.
Yeah.
which she did.
So you go through that process, because that, by going through that process, we now know we can tell a buyer says, yeah, here's the document, because the title company is going to need that documentation. And the court says her client has the authority to sell the property.
Yeah, and they
Laid off on the title company because they're going to need something, and they are. It's not just a.
Remember, they also decided they were not going to recognize the decision of the arbitrator.
We can't fix everything.
No.
But this brings up a good point. When you have a ruling from the court and parties that were involved said, we don't recognize that, then we say to your client, then you've got to resolve this before you get it on the market.
Yeah, and it was a time.
Now, you've got to talk to your own attorney. And if your attorney says, you know what, they're wrong, the court rules, and we're going to go forward and sell it. But here's the risk of how we deal with that. We support our client who operates under advice of counsel. If you're operating under advice of counsel, we're good.
And that's what her attorney did.
Yeah.
And the title company, after her attorney contacted them, and they said, okay, we know.
And if the title company finally resolves that and says, yeah, we're good, it's what the court says, what the attorney says, then they'll move forward because they then understand the risk is minimal because they're operating under advice of counsel. They have the right to rely on court decision, to rely on advice of counsel, and move forward. It protects them from being liable. So that's a good point.
And I did not take that listing until Bob told me I could have that listing. I'm serious.
So we understand the listing agent, what they want from the seller, they're actually the seller, and they give us good information. Because we're relying on, when we work up an estimate of seller's proceeds, one of the things that we get from them for financing is their estimate of payoff, which they can be way off on that. And that's why we always say on the estimate of seller proceeds, it's an estimate and relying on this information that's been provided to us and can be totally wrong. So we're relying on the seller has that information. The other thing that you're relying on is access to the property. You can make sure that everybody who, if it's an occupied property, everybody who's occupying the property is on board with marketing that property with access to the property. You find this especially a challenge in a divorce situation in which a divorce has been filed and one of them is living there and the other's moved out, but the one who's living there is not totally happy with the divorce agreement. And that person can make it a real problem for showing the property. And so you need to understand how that's working out because you're taking on an extra load to be able to market that property because you've got to have everybody on board. When you got that ex-wife and ex-seller, ex-husband, both on the lease agreement, you represent them both equal. And you're operating under advice of counsel from both sides. They've got to be on board or you're just spinning your wheels. You just tap in and say, well, I just need to practice or do lots and lots of work and not get paid. It's not practicing. So as you work through the process, we're sure we're talking about the seller. What does a buyer's agent expect of the seller? Do what?
Disclosure.
Yeah, we do want the seller to disclose what they know about the property. If they fall into one of those 11 specific exceptions, Section 5.008 of the Texas Property Code, you need to be familiar with those. If they say, well, we don't have to do seller disclosure notice because they need to be one of those 11 on the list of exemptions that it takes property code. Because if you get an offer on this property and, MB3 is checked off, you don't have to provide this, you need to know why they think they don't have to provide it. So you need to be familiar. And generally, you're going to see the rules are such that it's, that makes sense. They're a trustee, and if it's a lender who's operating property as a mortgagee. It's divorcing spouses. It's all things that they would be exempt because the court said, yeah, you don't really know. However, we get into some challenges with people who bought the property out unseen and say they don't know anything. That doesn't get them on the list. Being clueless about the property doesn't get you on the list. Work through. You may have been an executor under the will, but you may have now inherited the property. Well, when you inherited the property, you now own it. You just went off the list and you have to do a seller disclosure. You may say, well, Heard of the property, but I've never seen, never been there. One entirely sure I was somewhere in Plano, I don't know, whatever that. You still have to complete, you still have to tell us what you know or don't know as you work through it. What the exemption do to the value? If the value of the improvement is less than 5% of the value of the property, then it's exempt, like you've got a shed or something like that. All down that has no real improvement value. So you need to be familiar with those exemptions. So when you're going through the process and the seller said, well, I'm exempt, and you say, well, okay, why? Now, listen, you should have picked up on that and should have said, well, you're really not exempt. You really need to do this. So what else should the buyer's agent expect of a seller? Disclosure of the existing property, all the property documentation there. Access to the property. They need to be cooperating and work with access to the property. There's certain things they need to do that complies with the contract itself. We got one right now where we have a buyer, RHN is a buyer, and the seller and the listing agent are related. And we're going to execute a contract. And evidently the listing agent, who is related to the seller, is having things done at his house and is temporarily going to move into the property. Well, this is a property that under contract was vacant. We had a certain access situation. And now we've got the listing agent who's moved into the property and said, I have 24-hour notice, nothing's changing in terms of what's going on here. And we think, because one of the things we have in paragraph 4 of the contract, which you've got the contract there, after we have the contract, seller cannot enter into any leases, do anything to transfer interest in the property without permission of the buyer. And we think that having his, in this case, I think his brother-in-law, having his brother-in-law agent move into the house is at least under an implied or verbal lease, and that's transferring some interest in the property. And so, you know, it's a good sized piece of property. It's like $1.5 million, something like that. So we're trying to work with the seller / the listing agent who's kind of moved in the property, and the seller, his brother-in-law, try to work through it. But it's important for us to understand here's what the contract says, here's what you can do and not do. When you have some of those kinds of things shift because you know the concepts in the contract, and you can address it and deal with it. But when the seller makes changes like that they're not allowed to make under the terms of the contract, you and the buyer have got to make some decisions. You know, here's what we're going to do, here's how we're going to work through that. Because we expect a buyer's agent, we expect that access. We expect the seller to do what he agreed to do when we first entered into the contract. If any of that stuff changes, we need to have a conversation. We need to work through it. What is it about his question? Yes, sir.
So, so the seller and the listing agent in that situation right there, so they couldn't even do a seller's lease or anything like that. No, that's something.
The seller lease back is what the seller going to say in the property, not a third party. That's a good thought. Well, yeah, 4A, which deals with an addendum regarding residential leases. We generally look at that as when there's a written lease, but it really covers also any lease, either verbal or month-to-month.
Is that before the contract?
See, that's when that should have happened at the beginning of the contract. Right. That's something that should have been done by the parties. It should have been part of the offer. Right. I don't know if it wasn't because they hadn't really talked about it yet. And this was something that happened to the listing agent after the fact, say, oh, I really need a place to stay for a couple months or weeks or whatever.
But before that happened, they should have talked to the buyer.
Absolutely should have that conversation. Here's something going to change before we let this, our brother-in-law move in. Let's talk to the buyer. It's like, yeah, that's true. They understand.
It changes the concept.
Maybe it changes the terms of the contract. Maybe it changes what the parties have agreed to do. But what it really comes down to in cases like this is who's going to push the hardest. And the buyer says, you know, I still want the house, let's try to work through it. Because one of the things that this access issue changes is, you know, the buyer has contractors who want to have promoted HVAC, something of that nature. Well, they don't give you an exact time. You've got to arrange a time. And so, and one of the other things that the listing agent did when he moved in properties, he took the lockbox off. So you can only access the property if the agent's there. He's actually top. And so far, I haven't had to have a conversation, but our agent, who's one of our best agents, has sent me everything. I said, if it gets to that point where we need to talk to his broker supervisor, let me know and we'll do it. But it's just, you know, people just they do things and they don't understand, because he didn't understand the concepts of what had been agreed to by the parties in the contract. And by understanding the concepts and the expectations, he shouldn't have done that. He should have had the conversation, should have had a respectful conversation. Here's what we need to do. Unless the agent has got a problem in his house that you're having to repair something or whatever, it's going to take a couple of weeks. So, you know, it's family, so we'll let him move in. Let's have that conversation. Let's decide how we're going to work through that, what we have to do, primarily how it affects access to the property. Let's make sure we get that worked out. It could be a little bit of a challenge. The title company, what's the title company expecting the seller? Show up at closing, you get that. Yeah, there's really not a lot to fill out. The complaint I hear from title companies about actually both parties is responsive, you're providing the information back to them. That information should get back to them so they know what to deal with. The seller, if there's financing, getting that payoff, getting those things done. Any liens that pop up, what's the seller doing about those? But being responsive as you kind of work through that process. Deal with that. With the next page, expectations and the different phases of the transaction. Because if you look at the different phases, the primarily the offering process, executing contract, closing, different expectations. So in the offering process, what's the buyer what are they expecting to have happen, and who do they look to for all this?
For a response.
Yeah, but who are they looking to help them get through this offering process? Their agent. Yeah, their agent help them through it. Because in the offering process, what's so important for the buyer to understand the actual process, how they make an offer, who's the offer made to, what kind of, who are we relying on for some kind of response? How do we get from this to the executed contract, which is the next part here? And the buyer's looking to their agent to explain it. It's more true than on the seller side, that a buyer may not understand the process, particularly if every time they bought a house, it's been from a builder, sit down, builder rep, sign, deal done. They've never been through this back and forth. If presented an offer, got a counter, back and forth, negotiating back. You've never had that process. You've never gone through the process of inspections on the property and appraisal on the property and all those kinds of things. It's really important that the buyer understand the offering process, the timing of it, what's going to happen, what can happen to go through the offering process. So that's very important for the buyer to understand it. Now, this rolls to the expectation of a buyer's agent, because we know how important it is for the buyer to understand all this. What's the expectation that the buyer's agent is going to have in this offering process? What do they expect to have happen?
Get a notification of acceptance.
Yeah, send it over the other side, get some reaction, get some response, get something going. So the concept of the buyer's agent of the offering process is they want it to become a contract. So they want it successful. They're going to make sure they help their buyer understand, here's the process, here's what we're going to do, here's how it works. Because they say, our goal here is to have your offer accepted, whether it's initially or back and forth, offer a counter offer. So our goal here is to end up in an executed contract. And buyer's agent expects the buyer to cooperate and deal with that. What the buyer's agent has to look at is what's going on with their buyer, how convenient it is, what their buyer situation is, what the circumstances are they remote, what's going on. And so the buyer's agent has these expectations of this offering process and how complicated it may or may not be as you work through it. This is where it gets into how your buyer communicates. You work through it. So really got to be able to deal with that. So buyer's agent needs to, in order for the buyer's agent to do all that, the buyer's agent needs to know what's the paperwork. What do we use to make that offer? What do we use as we get it back? In one of our other classes where we talk about the offer counter offer process and how it goes to contract closing. I mean, there's a whole class on just that. It's really important for everybody to understand, here's how that happens. And here's the difference. When a buyer sends an offer over, the response can be a verbal response, which I hate. email coming back, said, oh yeah, we like that, but, or, and I like this, let's say you provide to the seller that great little form, invitation for a buyer to submit a new offer, which is not a counter offer, but it's good information. So sends it back to the buyer and says, you know, would more favorably review your offer if you would. And you can put a list of, well, here are the things I would like you to do. And that's a good response. It gives the buyer, say, okay, that's good information. I can look at that and see what I'll do for you in that situation. Hello, Tommy. How the heck are you? Did you bring popcorn?
Yeah, a lot of popcorn.
It's going to be a lot of popcorn. Well, and we got screens here. It's not as good as Top Gun. You know, we looked at Top Gun. Here's the experience I had. Those of you who made it to the Top Gun that they always did, it was an incredible experience. My 11-year-old grandson went with our good friend down the street. They went to see, I think, Saturday, Top Gun. 11-year-old boy whose life is video and gaming and computer. So I said, so how'd you like it? And here's a kid who's Jurassic Park and all this other. He said, Papa, that was the best movie I have ever seen. Wow. Now, that's incredible from an 11-year-old. Yeah. I said, because his problem with movies is that it's too slow. I said, so it was actually called. It was great. So it was pretty cool. You kind of work through that. So as we're going through the process and dealing with, make sure that we understand this process back and forth. So your buyer understand maybe an offer, counter offer, how this works. What I want you to do in the offering process is avoid all these verbals and emails back and forth. And I understand, well, we're pretty far apart. We want to see if there's any possibility here. But use that other form, do something else. Because the problem is we do the emails back and forth and all of a sudden someone said, okay, well, then yeah, if I do that, we got a contract. Well, that's not what it means. And yet we've had to go through the process to avoid lawsuits when we had someone who said, well, your agent said we got a deal, so we know we're in contract. So we don't understand why the seller entered into a contract with somebody else because they're in a contract with us. And we were just this close to a lawsuit. And we had a lot of attorneys involved. The buyer was an attorney. The buyer's agent was an attorney. So we just all kinds of, hang out the woodwork. But that's what I do is deal with all of it. So you have to be very careful on these emails, these verbals back and forth, because people all of a sudden think, well, hey, here's what I've got. That's why that form is so good, because it's not a counter offer. And so it says, hey, I would view your offer more favorably if. And you send that out. If you just have one offer, you can use that. You have multiple offers, you can use that. And you can put something different for each buyer who sends you an offer. It's just that form called. It's invitation to submit new offer. Invitation to buyer to submit new offer.
1926.
1926. It's XR 1926. Thank you very much, Cynthia. It's a really good form that the seller can use. By the way, a buyer could use it on a counter offer. Buyer could use it in the process, but it's really good because we don't want people to presume if I do this, you're just now telling me we got a contract. Oh, that's not what we're telling you. We're just trying to get closer. Jeannie?
Are you okay with, like, if I'm on the selling side? We don't even.
Are we okay with what?
Are you okay that if, let's just say I'm on the selling side?
You're the buyer or the seller?
I am the seller. Okay. And rather than go through any blah, 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 I just we pick our person and then we send it back to send another contract.
Okay, so, yeah, so if I understand it, you represent the seller and you've received multiple offers.
Yes.
Your seller said, here's the one I want to work.
Yes.
And so the seller makes whatever changes or does what he wants to, and you send that back to the buyer.
Without any, emails or anything. Are you okay?
You just send that back and that's okay.
Yeah.
What your seller needs to understand is that until that's accepted or acted on, or until they withdraw it, they're tied to that.
Oh, they have to. Oh,
you're tied to that. So when you make that, when the seller makes a counter offer, because remember the seller can't sell the same piece of property to multiple buyers.
Okay.
So when the seller makes that counter offer, if he does what Jeannie's talking about, he's taken it, he's made whatever changes, his initial by the person, 8 pages, sign page, sign that. So he's done everything physically he's required to do. We'll send it back to the buyer. Now we're looking for the buyer to ideally accept it by making the initial thing. But what the seller's just done is made a written counter offer, and he's tied to that until he either withdraws it or until the buyer acts. If the buyer either acts on it in some way, rejects it, counters it, accepts it, until that happens, the seller can't entertain or look at another buyer's offer. If another better offer comes in, then before the seller can entertain the other offer, the seller has to withdraw this first offer. And they've got to withdraw it before they get communication from the buyer that they've accepted the seller's counter.
Okay.
If the buyer sends over and says, look, great, we can accept all that, we can give, we've initial, we've signed, we have an executed contract, we've already worked. Then the seller can no longer withdraw, they're in the contract.
Okay.
So when you do that, and I like that because it's good, clear, point by point by point, but seller needs to understand here's the risk. If the perfect offer comes in 10 minutes later, here's what you have to do before you can entertain that other offer. You've got to withdraw this one.
That's why the invitation to, because there's you send out invitation to amend to 100 people if you want it.
Well,
And it's not a counter offer. So like you can invite more than one person to raise their price, change the terms, and then you're not. But
if your seller, where this happens, and I understand where you come from, the seller says, you know what, this is the only really good offer in the 5 we received. And if we can get the buyer to get on board with these things, we want to get this house up. We want to get this done. And that's a significant commitment because this buyer now sees, the buyer's agencies, the seller has made a serious commitment. The seller just didn't send an email over or an invitation to new offer. They made a counter offer, they signed off on it. And so all our buyer has to do is now initial and sign it. We've got to and communicate that acceptance. We got a contract. But until that communication happens, we don't have a contract. So that's a good way to do it as long as the seller understands, here's what I've committed to. Here's what I've agreed to do. Makes semi-sense.
It's in my.
That's in my. And once you've heard it 10 times, it'll make really good sense. Right? Bradley, your question? Okay, that's okay. Let's work through it. So in this whole offering process, we need to make sure buyer's agent makes sure the buyer understands that whole process. The listing agent in this offering process, we just talked about this. Listing agent needs to understand what has to happen, what their obligations or options are when they receive an offer on their listing. It's going to all come down to the seller and the seller's decision. Because remember, what does the seller not have to do in Texas? Yeah, well, they don't have to do anything. They don't have to do anything. They don't even have to acknowledge the existing offer. They don't have to do anything. Now, Trek kind of says, Texas Realtor kind of says, as a listing agent, as a fellow realtor, you need to kind of do something. You need to encourage seller, if you're not going to do anything, let me let your buyer's agent know, because you got a buyer anxious to hear something, that the seller circumstances are such that you're not in a position to respond. Yeah. Something more through the process. Seller's not required to do anything. So listing agent needs to make sure in this offering process that their seller understands, here's how this works. You receive an offer, and here are your options. One is take a nap. I mean, you look on sleep anyway. So go take a nap. They have lunch and they go have pasta for lunch. They go take a nap. Or you can just out and out reject it. This is the dumbest offer I have ever seen. And tell them no, heck no. Or seller can counter. Say, here's what I'd like to do. We need to use the form I just talked about. Or a seller accept it. Now, when the seller receives an offer, here's what we presume we have. On a written form, on track promulgated form, the buyer has totally completed the offer. Full completion. The buyer's initial bottom of first 10 pages, sign page 8, done everything that they physically have to do, signed all addendums. The buyer's done everything they're physically required to do, so that when it gets to the seller, if the seller accepts it and communicates that acceptance, we have a contract. So physically, the buyer's done everything they're required to do. So when the seller gets it, the buyer's not required to do anything more. If the seller fully accepts it, initials, signs off, that's communicated, we have a contract. If the seller counters, when the seller counters, and the seller needs to know this, when they counter the buyer's offer, they've just avoided that buyer's offer. And the buyer no longer has any obligation to that seller. They go out and buy somebody else's house. Because let's remember, a buyer can have multiple contracts at the same time. Seller can't be, but on the same property, there are buyers. So the seller in that situation needs to understand that anything less than full acceptance, we may never hear from that buyer again. Now, that's not a reason in and of itself to accept an offer that's not acceptable. But the seller just needs to know that's the process. So the seller needs to understand that listing process, understand their choices. And if acceptance happens, remember an important element of acceptance, not delivery, communication. The side that fully accepts the offer has to communicate that to the other side. So if the seller fully accepts, this is great, good job, this is perfect, sign here, done up, done everything. Listing agent then communicates to the buyer's agent. My seller has physically done everything required to do, initial signed everything. We have an executed contract. That communication creates a contract. Until that happens, we don't have a contract. Tommy?
What's the forms of communication?
There is no form of communication except the contract itself. Yeah, an email is best, because here's why an email is best. And if I recall correctly, you had a situation a few years ago. What's good about an email is we've got a timestamp. Because what you may have is says, great, I accept it. And the buyer's given some more thought to this. You know, now that I think about it, I've heard people from Oklahoma live in this neighborhood. Why would I buy a neighborhood like that? And so the buyer is getting ready to withdraw their offer. Well, if the seller communicates acceptance before the buyer withdraws the offer, we have a contract. So that's why it's important to have some documentation beyond just a phone call, such as an email with a time, date, and everything on it. So that we know we communicate that acceptance and we're in a contract. And there is no form for that. An email is accepted by the courts all day long. Yes, sir.
Verbal is not.
Well, here's the problem. A verbal acceptance creates a contract. The problem is proving it up. Because what happens, and you actually had this happen a number of years ago. You probably don't remember the transaction. I remember it because we had to work through it. We had a verbal acceptance. And we had a verbal counter and a verbal acceptance. And the problem is proving it up because the other side denied it. No. We didn't say that. We don't have a contract. And we said, yeah, we do. Because what happens in your situation, you got the seller and buyer made an offer and the seller had accepted it or felt like they accepted it. And as I recall, correct me if I'm wrong on this, you had communicated back to the buyer's agent that the seller had accepted it. Because the seller signed off, but another better offer came in. The seller said, well, I want to take that. And so the seller said to you, you said, well, you're in contract. Well, have you sent it to the other side? Have you delivered to the other side? Well, no, but I called and I told them that you've accepted and we've got a contract. I said, I don't think I've got a contract. I think that, how are they going to prove up that conversation? And as I recall, this is one of the reasons I really like you, is you said, my testimony in court will be that you accepted it and I communicated that to the other side. That's how you prove up the conversation. You couldn't get past that. And there wasn't a huge difference in the offers for the two contracts. He said, okay, fine. But the problem with verbal is proving it up. Unless you've got somebody else who's willing to step up and say, that did happen. And I know we don't have documentation, but a verbal acceptance creates a contract. It's proving it up. It's the challenge. Do you remember that at all?
I do. It was Vicky Mox. We had fax machines at that time. It's serious. I'm back to Vicky, and the timestamp on the fax machine was wrong. And it was wrong. And she said, and we got caught at it. And I was like, are you jacking with me? So
you remember the fax machine we used to have back here? It was off by a couple of minutes.
No, that's right.
I mean, literally. So when you thought that you were saying something at 11:59 p.m., it was actually 12:01 a.m. It was the next day. Yeah. And so you had a problem there.
I went up there at 11:59.
That was after.
Yeah, work through it. So we're looking through the process, the offering process, and the seller expectation, the offering process, because the listing agent is going to explain to them, here's how that works. Here are your options, what you can do. As we just talked about as you go through it. Because the seller wants to know, how do I get from happy to get an offer? Yes, sir.
I'm going to go set time on my fax machine.
So the seller's going to want to know, how do I get from this offering stuff that we're doing to get to a contract? I want a contract. I want to sell the house. So you need to make sure they understand Here's the steps. Here's how we get from this to this, kind of make that work. Now, to our ideal situation, we get into an executed contract. And we just talked about how we go from the offer to an executed contract, where we have that communication of full acceptance, so that neither side has anything physically that they need to do. Both sides have initials, every change, every place in the contract, just the bottom of the pages, they've signed off on it, and that's been communicated. We had a situation in which the agent said, yeah, this is one of our, the agent said, yeah, my seller, and our agent had seller, my seller has accepted your buyer's offer. So we've got a contract. And unfortunately, the listing agent said in a little bit of a follow-up, and I'm going to get with him in a couple of hours and he's going to sign off.
Oh.
We didn't have a contract. Because the seller, you have to communicate, the seller physically has done everything they're required to do. The seller hadn't done that. The seller had verbally said to the listing agent, yeah, I'll do all that. All the stuff buyers asked for, I'm good with that. But hadn't signed it, hadn't executed the contract. So we didn't have a contract. And created a little bit of challenges we had to work through. But so as you're dealing with it, to get execute contract, both sides have to physically done everything you're required to do. And that's been, yeah, a lot of brokers said, well, I like communication because that's what the law says. But I want delivery. And delivery is a little bit more emphatic and more there. Right up until the time where they deny they were received. Emails are harder to deny interesting enough than a physical delivery. You know how you deliver it. You know, the reality is one thing, if you've ever, I would encourage you sometimes to sit in on courts and watch sometimes what the attorneys do. One of the realities is a good attorney can question your ability to prove that you're even right there at that point. I mean, what they're taught in law school about how you prove things and disprove things. And so sometimes delivery of something. You say, well, okay, you delivered it. Okay. Was it raining on that good day? Who you delivered to? What were you wearing? You know, just as you go down the process, sometimes it's hard to prove something has happened. You know it happened. Process. I mean, but execute, yeah, take a picture. Yeah, take a picture. See, I'm with you on that. Take a picture. And then make sure it's a picture that has a timestamp. So we have an executed contract. So we've defined and we know what that means. We've got an executed contract. So we're good on that. What's the seller's expectation now that we have an executed contract? What do they think happens at that point? What do they think we've got?
The house is sold.
House is sold, but it isn't, is it?
No. Not till closing.
Not until we have closing and funding. But so the seller needs to understand, here's that first step. So the listing agent make sure the seller understands, here's what we have. It's a great move forward. But what we know, and we know it in our heart of hearts, not all contracts close. For a gazillion different reasons. And sometimes one of the reasons that contracts don't close is people die. And it's just a hard reality of life. Buyers and sellers don't come to closing. It's that. And while you can vote in a number of states, if you're dead, you can't close in state. Cynical Bob. So seller said, and seller would say, oh, great. Back some agent said, good news, we stole the house. Okay, so where's my money? Yeah. Well, that is a couple months later. Deal with that later. Yeah. But seller has his expectation as you go through and deal with that. And so you have to make sure, and this gets to that next process of dealing with the contract closing process. Seller needs to understand now that's a great start. We've got a binding contract. Each side now has things they're required to do, performances they're required to do. So everybody has that. And here's what that means. And then we take to the next step and we go through the process of dealing with the contract closing process. But the listing agent really needs to make sure they temper what the seller is thinking, what their expectation is. Here's what we've got right now. So here are all the steps from this point that we'll get to the next page of the executing contract closing process. Same thing with the buyer. I said, great, got the house. In fact, buyers in a contract to buy a house, you'll get a call from your buyer. You know what my sellers are doing to my house? They're having an open house this weekend. They're having an open house on my house. What's going on here? they've already taken ownership because they've got a contract on it. Well, no. So you need to help temper the buyers' their thoughts and decisions. Now, the agents have to be really careful because the agents sit back saying, oh, great, got my Mercedes taken care of, but money coming in. One of the early things I learned, my father, who retired from the Air Force and then went real estate for 20 plus years. Early on, like in the first few months, I had a couple of deals coming in. He said, son, don't ever write checks on the way to closing. What? What? Don't ever write checks that you expect to be covered by money you get at closing. Because what happens if it doesn't close? It was a bad check. And he really upset us. And it took me a while. Yeah, he's right. Because we have that anticipation. Agents say, okay, you got to close. Now they know, agents know better than buyer teller. There's a process. But you do, you have a tendency to start counting that money. You can't do it until the check gets cut. Until the check gets cut by Max and me or Jill or Mike signs off on it. He'll only do that once he's got the CDA and all the stuff in the title company, so we got closing and funding.
And stickers.
And
stickers. And
stickers. Well, I thought you needed to give him that stickers wrapped in $100 bill. Okay, now let's look at what happened next on that contract closing process. So this is how we're going to go. We've already established we've got an executed contract now, and here's how we're going to go from that executed contract to a closing. What is the buyer's expectation of this process? Because one, they've got some expectation before you even start talking to them. They got some idea. Okay, we found a house, we got a contract, and based on their past experience, they've got some idea about here's kind of what happens now. Here's that expectation. They may have it because their lenders told them certain things, but you really need to rely on what you're telling them. You need for them to understand, here's the process now, here's how we go through it, here's the timing. Here's when you need to come up with money. Here's when you need to write that earnest money check. Here's when you do that option fee. Here's when you need to wire those funds. Here's when you do about the appraisal, about the inspection. Here are all the elements of the process from contract closing. And let me introduce you to your fine transaction coordinator, Celine, so she can take care of you from there to there. We're going to do that. But you need to make sure they understand that process because they won't automatically understand it. And they understand all the pieces of it because we're relying heavily on that buyer and seller to do all the things we need to do to get to closing. So you need to make sure they understand. And by the way, that process is going to be different depending on the contract. The timing is going to be different depending on the contract. So you need to make sure they understand that process, which means you need to understand the process. For you to be able to make sure they understand it, explain it to them, that's when you're going to really step up your communication with your client. Make sure they understand. Here's when we're going to communicate, and here are the different points in this process from now to closing. And here's when we're going to communicate, and here's why, what's going to happen. Making sure you get to that final point, 3 days prior to closing on the CD, making sure that they get that from the lender and they sign off on it. So the lender has that so they can do the clear close and go through that process. So you need to make sure that they understand each point, which is going to be really important communication from you or your transaction coordinator or your admin assistant, whoever you got to work through that. Make sure that communication happens because you don't want that antsy buyer to get all excited, get all upset, and think things are going bad or whatever. All of a sudden they get really nervous because there's a tendency for buyers anyway to have a little bit of buyer's remorse after that contract. Gosh, that's a lot of money. Wow. Can we really afford that? You start thinking about it, going through the process. So you want to make it a nice, smooth situation, and their expectations need to be met all the way through the process, especially if it's going to take any kind of time. Now, you've got financing involved, take 30, 45 days, like that. But even in cash transactions, if we try to close in 10 or 14 days, primarily relying on the challenge with the title company and getting through their process. You need to make sure they understand here are all the points in time, and you've got to be on top of it to work through it. As you're going through the process, your buyer needs to understand in the contract all the things that have been addressed in the contract, all their performance requirements, and all the contingencies, all the things that create certain rights for them. And we're talking, in fact, we've got a whole class on contingencies and termination rights. So you need to make sure that they understand that going through the process. Now, understanding those are all responsibility dealing with the buyer's expectation. And so that next person in there, the buyer's agent has an expectation of what they expect the buyer to be able to do going through the process. Which means the buyer's agent needs to understand that process. And here's the key, they need to understand it well enough to explain it to someone who's clueless about the whole process. One of your really important communication skills is when you explain, here's what's going to happen. Be listening to or watching your buyer and see if they get it. You don't want a buyer who keeps nodding, oh, yeah, okay, yeah. And even worse, oh yeah, I know. Yeah, I know. Yeah, I knew that. Yeah, it's okay. Yeah, we're good. No, that's when you have to really stay on top of keep working through that process, make sure they really understand. So the buyer's agent who understands all these things, their expectation is their buyer is going to work with them. One of the challenges you have is when the buyer starts ghosting them and you can't get in touch with them. I know a transaction, one of our agents, we're probably 2 or 3 weeks in the transaction and all of a sudden the buyer totally disappeared. They weren't at their job anymore, they weren't answering phones anymore, they weren't where we thought they lived anymore. I mean, they literally totally disappeared. But we had a buyer that we represented who was in contract to buy a piece of property. And you know, we can't make someone to respond to us. We can't make someone answer the phone call. In a situation like that, you know, as we work through the process, you have to be careful how far you go. I mean, first, they could have been dead and don't know what could have happened. Even worse, they're going to move to Oklahoma. And then, you know, what are you going to do then? But as you work through the process, you've got certain obligations because the listing agent will be hounding you. You know, what's going on with your buyer? They got this done, they got that done. And without violating any confidentiality with your buyer, you guys say, well, I haven't actually heard from my buyer lately. What's late? Well, ever. I had a good relationship first week and then silent. You may not want to go that far until you're several weeks into it, but that's a challenge. That happens. So the expectation of buyer's agent is the buyer's going to be working with it. The buyer's going to communicate. When I need information, the buyer's going to, and the buyer's going to be providing the information that the lender needs, that their lender needs. We've got a lender on this list here, but there's certain expectations. You have to be prepared when all the things that ideally should happen don't. Now, you don't begin to go around and be gloomy, Gus, and all. I guess, oh, it's terrible as I have, you know, but you have to be prepared so that when things don't go exactly as we expect them to, you make adjustments, you get it done. One of the great marks of good agents is they make those adjustments. And things happen, and this is when the value is great when agents are working well together. Some things happen, the 2 agents can begin to work this out and talk about things and get things done and get the adjustments done and make it work. This requires everybody to kind of work through. So you can do that if you're prepared for it. But now you can only be prepared to make those adjustments if you know something is supposed to have happened and it didn't. If you're clueless about the process and what's supposed to happen when it's supposed to happen, then you won't know that, oops, this was supposed to happen and it didn't. Once you know, hey, this is supposed to happen, this is supposed to happen, and none of it happened, then you begin to work with the other agent, begin to work it out, work with your client, get it adjusted, make it through the process. And most of the time, I mean, literally, probably 90% of the time, it gets worked out. You know, what I deal with, and Marcia, when I deal with on a regular basis, is the problems and the disputes and the challenges, and the lawsuits and complaints and the deals that fall out and don't close. You don't. 90% of the time, your deal goes fine, it closes, it goes through the process, everything's good. I mean, that's the vast majority of cases I have. So you need to be very obstinate. It's just sometimes it takes a little tweaking to make some adjustments to get through the process. And that really, frankly, takes both agents work through that process to do that tweaking to get it from contract to closing. But because you know all the things that are required, all the things that are expected, you can quickly do that. You go through that process and make sure that gets done. That makes semi-sense. So we just brought Bernie and both the buyer's agent listening here. The seller going through the process. Again, the seller has an expectation. The really interesting thing, the buyer in a contract, their criteria in a contract is the buyer needs to know Make sure that the property is in the condition and the value that it's worth them buying it. What the seller really needs to know is how much money am I going to get and when do I get it? That's really a big deal for the seller. So when communicating with the seller is, here are all the things that need to happen for you to get the closing and get paid. And it's a much simpler and easier process to deal with the seller. The lender, in the contract closing, we need to make sure the lender is doing all the things like Holly pointed out earlier, that the lender is doing all the steps. We don't want the lender who waits 2 weeks prior to closing to first look at the contract. They've got a stack. This is the lender who was doing business primarily, most of their business with refi, and they weren't doing all that many purchases. They've got a purchase contract and they really don't understand all the tight time frames that are involved in a purchase contract. And you have to really make sure it works with them. Title company, we rely greatly on the title company. Make sure they understand all the pieces of the puzzle. You need to rely on it. Title company is what's going to finally make all this stuff work going through it. So we can get to that great thing, that closing. We need to make sure everybody understands when it's going to happen, where it's going to happen, how it's going to happen, and who's going to be involved. If you have people that are going to be remote, people out of state or whatever, you need to prepare for that ahead of time. If you've got people with different language situations where you're going to have interpreters, you have other people there, you've got to understand entitlements will be very involved in the whole process. Now, we're about to run out of time because I want to get to this last point, miscellaneous, dealing with these. These are all important little critical points. One, seller temporary residential lease, which is used a lot. Sellers say, yeah, I need a few weeks or a few days or whatever. We need to understand the risk of seller temporary residential lease. There are a lot of risks of both seller and the buyer that you work through. Now, the seller temporary residential lease, the expectation of the seller is that, yeah, I get to stay in the property past closing for whatever I need, a few days, or weeks, whatever. And generally sells in, and I'm not going to pay anything. It's going to be a freebie, so I get to do that. That's what they're negotiating. And seller has that expectation. That's okay. They put the terms in paragraph 3 of the residential lease, deal with the term of it. When it starts, it terminates. One of our challenges, termination, paragraph 3, the term, and then seller temporary residential lease, is it starts, and the contract closes and funds, and it terminates, and it's got a blank. And that blank, you can either have a date or you can put a number of days. But you have to put a number of days, you have to indicate what it's tied to. And we're just going through a situation where there's a different interpretation because the buyer intentionally put in closing, not closing and funding, wanting to make a decision because what happened is the closing and the funding happened 4 days difference. And the buyer is using that as an excuse to be able to work things out, saying, yeah, it got worked out.
Who was that? What team had that?
I don't know. I can't believe it. But it's a great example of it got worked out. Agents work things out. Buyer and seller worked in it. Because this gets to a little bit of what the buyer expects. Yeah, okay. Seller's going to be there for some period of time. And this expectation of the buyer is going to be, and when they move out, they're going to move out within the time frame that we've agreed to in the lease. And it's going to be in the condition we expect it to be. For the repairs still need to be done, not be done. So that's going to be expectation of the buyer. The problem with the agents involved with the agents is we're not involved. We've had a closing, we're through, we're done. And you've got a relationship with the buyer or seller that you may want to continue at some point in time. But if things happen during that 2 or 3 weeks or 30 days or whatever the time frame is, the parties have got to work it out. We've got a closing. So the seller / landlord, seller / tenant, buyer / landlord have to work out whatever the challenge is. The risk to the buyer is the seller doesn't leave it in time, doesn't leave it in the condition it's supposed to be. Risk, to the seller in the situation is he didn't really read. So wait a minute, paragraph 13, buyer has access to the property. He gets the keys. He gets the keys to the house that I own. Well, you don't own it anymore. Well, that I'm living in, yeah. You've got to provide them access to the property, provide them the keys. You've got to do that at closing. As you work through the process, well, because maybe if there's any kind of an adversarial relationship there, they don't want to do that. So there's a lot of risk in it. Of course, the big thing is making sure both parties, seller and buyer, have talked to their insurance agent about coverage during that time. That's credit agency, both the contract. It's also in the lease itself. Yes, ma'am.
Okay, I'm trying to understand. Closing and funding. I thought closing was when they fund. It's just
the lease itself. We actually make the distinction in paragraph 10 of the contract. We make the distinction or closing and funding. But you've got choices in possession at closing and funding, or possession or into temporary residential lease. So while we view technically a closing doesn't really happen until it's also funding. And in the lease, it actually makes that separation closing and funding. Because of this experience we just had, a buyer said, well, we want to separate closing and funding, and it got to be a dispute. We want to avoid anything that gets to be a dispute, which kind of gets to number 4 here, and we'll go back to 3, the language. Whenever there's a language in the contract or language in addendum, or in this case, language in the lease, I don't care which side you're on, but let's say you're the listing agent and the buyer's agent put this language in there. You need to understand that if you allow your client to sign off on it, it's now your language. It doesn't matter who initiated it, doesn't matter who started it. Unless you tell your client, I don't understand what this means, you need to seek legal advice before you accept it. Unless you do that, and you're going to do it in writing, such as an email, you're now responsible for that language. I just had a conversation, well, just it was 3 weeks ago now, with a Trek attorney. We spent over an hour in conversation, and one of them was, you know, your agent didn't put this in there, but your agent allowed it to stay in paragraph 11. And there's a redundant or other things in the contract. And it's because your agent let your client do it, your agent's responsible for that language. So we need to understand that responsibility, at least from the Trek perspective, as you go through that. So letting a buyer think that they've made a distinction between closing and funding without making sure that's worked out could create a liability for you as you work through it. Now, let's go back up to number. Does everybody understand on sell to release? A lot of risk. Number 2, mandatory HOA. Again, this is a Marcia thing. You need to understand in a mandatory homeowner association, but it was, that sometimes we don't understand the obligations of HOAs and what they're required to do. That sellers and buyers aren't required to do. So you need to make sure if there's any repairs or things that need to be done or issues or things that the parties look to the HOAs what they're going to do. Number 3, exclusions. Again, a Marcia thing. We have paragraph 2D of the contract for the seller list exclusions. You may have exclusions in your listing agreement. You may have exclusions in MLS. You may actually have things at the house. Signs on something saying, thanks for the compliment. You don't get it. We're taking it with us. None of that counts unless it's in paragraph 2D of the contract. So one of your obligations or expectation of the seller in the intro contract is understand if you think this is what's agreed to, it's got to be in the contract or it doesn't exist. And so you need to make sure that exclusions that parties are agreeing to are there. Otherwise, we could have as a minimum a dispute between the buyer and seller. Sometimes that gets worked out, doesn't it? Sally? Sometimes that gets worked out, doesn't it? In fact, that's a great sign. This is a great example of really good agents working things out. One of the things, and if you've been around me long enough, you'll know that one of the things I don't like is intermediary relationships. A lot of risk. The only good thing about an intermediary relationship is that both agents involved are in our office, so they're better trained. So we're more likely going to have a good transaction. Intermediary relationships are really not understood by the parties and by the clients and by the agents. It's a real challenge. Guys, great. Thank you for being here. Thank you for going through. Question. Okay.
Thank you very much, Bob. Tomorrow at 11 o'clock in this room, we have our team meeting, so everybody be there.
Oh yeah, good point. And there'll be lunch.
Yeah, there'll be lunch, yes. And then before that, at 8:30, I'll be teaching how to hold an open house. So anybody who's missed an open house or wants to see it again, feel free to come at 8:30.
Perfect. Thank you, Holly. Appreciate it. Thank you guys for being here. Thank you. Good questions. Thank you, Zoomers.
Thanks, Bob.
Thank you. Thank you. Stay up. Sir, appreciate you. Staying awake the entire time. That's good. Yeah. All right. Thanks.
Bye.
Thank you for being here.
Thank you.